All right, what's up, co-consuls? I had to switch things around a little bit because obviously there was a hearing today, so that's what we are going to cover. Instead, I've watched about maybe 40% of today's motion hearings at a meeting, so I had to disappear. But let's get into it. And Bev Canoni started off hot. Okay, she's not playing games. She came in ready to handle business.
What I'm going to start with
Let's.
is
What's up,
a
Benji?
decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told council before.
Benji's here, so we have to shout out all the swingers. Okay. Hopefully, you're having a good day. I'm tired. I'm really exhausted, but I'm here. I'm here.
That I
don't know. I don't know if you watch today's motion hearings or not, but I'm switching things over. Today's topic will be moved over to tomorrow. It's already scheduled. I just created a new live stream, but I thought it was important for us to cover what actually occurred in court today.
I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here.
Okay.
I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship
I have a comment
with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024.
Doesn't it like morning for you, Benji? Why are you taking a nap so early in the day? But you probably deserve it. You do work hard.
Payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation,
Right,
and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this.
Apparently, Bev Canoni was having an ex parte meeting with Karen Reed and her attorneys.
But I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So
okay. Let's fast forward. In all honesty, I am baffled as to why defense attorneys decided to lie about retaining and paying the experts. To me, it's a weird. Let me not say it's weird. It's an improper representation. I mean, that's very clear. Okay, but I do not understand why they thought it necessary to lie about paying experts. And the reason why it just doesn't make sense. It's because attorneys retain witnesses all the time. Literally, attorney retain witnesses all the time. Expert witnesses get paid for their testimony all the time. I am baffled as to why the defense in this case thought that it was proper for them to actually lie about. It's just, I don't know, it makes no sense to me. I don't know what they were trying to accomplish, but they got caught. And it created unnecessary, not just unnecessary stress, but they potentially could have put their client, the defendant in this case, in a rather difficult position.
All right. So
Like,
there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our
This was a stupid response by Jackson, by the way.
roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential.
I don't want to hear about folks saying Bev is biased anymore, because she very well could have revoked Jackson's pro hoc vice admission, okay, because he's not even licensed in Massachusetts. He was granted, what is this, limited authority basically for him to represent Karen Reed in this case. That said, though, in order for this, to me, this was the right decision in order for the case to actually proceed on April 1st. Because had Bev made a ruling otherwise, had she, decided to impose different sanctions and remove Jackson from this case, then they would have had to push this trial back. It would have, there's no way they would have had to proceed, or they could have proceeded with an April 1st trial date had she lost one of her attorneys.
Bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. Yeah. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Berman.
Yeah, that's what I was going to say. I'm curious to see what the cross-examination is going to look like in light of, this payment. I suppose it's just really going to be standard cross-examination. Prosecution is going to elicit that they were paid. I do not know that prosecution on cross-examination would be able to elicit that the defense lied about, the witnesses being paid. But I don't know. This is Brennan. Maybe he does, maybe he doesn't. I don't know how that would come in, but stranger things have happened.
And I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf.
Okay.
So I'll hear you on that.
Yep.
Thank you, Your Honor.
Just because there wasn't really much to it. Alex was arguing that the doctor does not satisfy the standards for an expert to be designated as such in Massachusetts. The prosecution did not really focus on the Daubert standard. He talked about some other stuff, but it's not worth.
Dr. Wolf's credentials. Dr. Wolf is not a neurologist. He's a neurosurgeon.
Motion
Okay. And then
to
let's
present
do
the
the part-
demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear.
So this portion was pretty much, the prosecution wants a demonstrative that's self-explanatory. Okay, it's usually an illustration that attorneys create in order to assist witnesses, sometimes to assist the finder of fact, the jury or judge, depending on who's making the decision in the case, or the defense. They want a demonstrative to come in. Prosecution says no, they're objecting. They don't want the demonstrative to come in. The prosecution's reason was that and the witness's report would not be able to come in. And apparently this demonstrative is pretty much an inaccurate summary of the report. And apparently there were some labelings that the prosecution did not agree with. So we're not really going to go into that because I don't know that Judge Canoni made a decision. I believe she said that she would actually make a ruling prior to the witness taking the stand. So that's not really worth getting into. But there's a portion here. Let me.
Official prior bad character and propensity evidence. It deals with the
Hold on.
official
Go back.
prior bad.
I think it's already an hour in.
So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba.
Okay. Benji, if you've not watched the first trial, okay, let me let Canoni finish talking. I'll explain what Aruba is.
Witnesses.
It's not like the island, but how it's relevant to this trial.
I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children?
This does not. This is
Okay.
limited. This argument will be limited to we'll call it the Aruba incident.
Okay, all right.
Okay, the way that I remember the Aruba incident, hopefully I'm putting it properly into frame. Karen Reed and the decedent vacationed in Aruba with a host of other, friends. And the way that I remember the testimony as it was admitted during the first trial, I believe they were trying to show that Karen Reed was jealous about interactions that the decedent had with, I don't want to say a mutual friend, but with, another woman during this trip. That's what I remember about Aruba. There might be more to it,
So given that, that might not
but I'm not going to focus on
include
that.
the Commonwealth's number 11, the quals, bans the defendant's statement. the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
What's up,
The
Brooklyn?
defendant-
So I just,
I take it that you actually watched the hearing. I can give them a like. Take it you watched the hearing. What were your thoughts or impressions?
just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
Mine is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce.
so I'll hear you.
Okay,
So
this is
I'm going to argue this for the defendant.
wasn't a part of this.
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay.
I was very disappointed in this attorney. Really disappointed in her. I suppose maybe she's getting her feet wet, but I don't know. I was not impressed.
So what's different this time around is you're asking
Yes.
that Ms.
Last name
Reed
Little.
be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Okay, so Brooklyn said that it was a dirty trap that Judge Bev played. In what sense? Give me something. Give me facts. What do you mean? Did you want her to remove what's his name again? Did you want her to remove Jackson, or what exactly are you referring to?
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow.
I was really disappointed. Again, maybe this is her first trial, so I was really disappointed in this attorney.
View under Massachusetts General Law 234A.
So I'll allow review.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
Mhm.
Man, she literally just said she's allowing the view. That's what
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I
Brennan
don't
is
think
pretty
that
sharp.
the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions. And I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the
Oh,
concerns.
so they're back tomorrow? I guess I'm going to have to move back the live or change the title, because I thought they would be back on Thursday.
I have about
Tomorrow, Wednesday?
just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some.
Brooklyn, I completely disagree with your assessment. We can go back to that part. Okay, so Brooklyn is saying that Bev Canoni played a dirty trap because apparently she asked who the lead counsel was, and Karen Reed. It was not Karen Reed. That was Jackson. Jackson said that there's no lead and everybody is equal. That is not. Listen. I'm an attorney that has actually gone to court over, not even just gone to court. I've tried a lot of cases. There's always a lead attorney, okay? Whether it's a prosecution or the defense, whether you call it lead, first chair, second chair, there's always somebody that's actually taking the lead. And then with the other part, apparently she couldn't bump off Alan Jackson. That has nothing to do with the question of whether he was lead attorney or not. The reason why Bev Canoni did not, what is this? The reason why Bev Canoni did not remove Alan Jackson from this trial is because had she done that, this case would not have been able to go April 1st. That's just a fact. And then, okay, Brooklyn said no Thursday. And then if it's at sidebar, it's information that you're not privy to. So how are you able to say that she played a dirty trap or she trapped them? I need more information, Brooklyn. Like, give me concrete information. But I'm telling you right now, Jackson's conduct was improper. You guys know I don't like people that play dirty. And not only is it improper, but he was trying to hide something that's not even worth hiding. Okay? Attorneys retain experts all the time. Experts get paid all the time. Attorneys, to a certain extent, do frame the testimony of experts. Like, yeah, experts are required to be neutral, impartial, but that's not always the case. I mean, that's why a specific side is calling a specific witness as opposed to just, drawing a random number and having a random expert testify. So that was just stupid. It was really stupid. It makes no sense. Unless that's how I wanted to say, unless that's how they play in California, but Tacopina is not from California. He's a New Yorker.
Proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with the proposal about viewing the car.
Here's my thing. I personally do not like it when attorneys play dirty. Okay. In this case, whether it's prosecution or defense, I've said that over and over again. In what is this? If we go back to the YSL trial, people were so outraged when, the prosecution would behave in a certain manner or do a certain thing. But when it comes to defendants that, most spectators are actually supporting and rooting for, then they tend to overlook. This is not just mishap. As Bev Canoni put it, it is a flagrant violation, okay? Candid to the court. That's 101 rules of professional responsibility. He knows that. And it's just, to me, it's really stupid. Like, why are you lying about something that is, it's just stupid. Like, out of everything you could have possibly lied about, that's what you choose to lie about when you easily could have just retained, paid them, disclose that to the court with no issues. That's just, I don't know. It's his license, though.
A separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars.
Shout out to Alessi, though.
All right. So defendant's motion limited to exclude certain witnesses before and after testimony.
This, I thought, there was an interesting motion.
It's 462, and I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. 562 and 576. So is Little?
Yeah, I don't know. Little was too shaky for me. Again, she might be getting her feet wet, but I don't know.
I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally excluding Brian Higgins and members of the Albert and McCabe families after they testify.
I don't know where the motion was interesting in a sense. I suppose interesting might not be the right verbiage here. It was a little bit of a head scratcher to me because they wanted these folks to be excluded after they have testified and pretty much the case has come to a close, the evidence has come to a close, which was the reasoning is what kind of, I'm like, I don't know if I agree with that.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is,
This is a baby defense attorney. She's getting her feet wet. I don't know about good because I don't know. She was too shaky for me.
closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes,
Focus on that part of your motion.
yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at
This is where it becomes problematic. Brooklyn says she's good. I disagree with that because she didn't have all her facts together.
fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know.
Exactly.
She was.
So
she-
that is the problem. You need to have your ducks in a row. You cannot come up here and claim there's, a phantom juror that was intimidated by the presence of Colin and other folks, but you don't actually know what their role was.
or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's
Well, maybe
Office
she
wanted
was
to have
nervous.
the third-party culprits seated there during closing arguments.
Maybe it's nerves, but
And so
yeah,
on that basis, the defense is requesting, in order to protect
defense attorney.
there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other
Girl,
expert
that is the 101 rules of evidence.
testimony that deals with their.
All right. So obviously is not something it should be in a motion.
The judge
testimony.
said, I'm sorry, but she a little shaky for me. But again, she does appear to be inexperienced. Let's go back there.
And the victim.
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously is not something it should be in a motion. Okay. If you've got an agreement that each other's experts can be in the courtroom during the testimony, it's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch.
Brooklyn
Our
said
experts
she
and
should
vice
have
versa.
solid
All right.
evidence.
So you all need to talk.
They don't want turtle.
All right.
going forward.
And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given. Okay.
All right.
All All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned
has nice
about
socks
after the
on.
evidence is closed.
My socks never match. Sometimes they don't always match.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets.
Oh, did you watch Lori today, Brooklyn? I watched a little bit of Lori Vallow. I believe that's her last name. The disappointing part for me, though, is that she is on trial at the same time as Karen Reed. I cannot divide myself that way. But yeah, I don't know. They should have, again, different jurisdictions. They don't care what's happening in Massachusetts. But that girl, I don't know. Maybe Lori might be the best pro se defendant that I've actually seen. Okay, maybe that girl had case law. She was referring to her what is this, her paralegal, the investigators. She still should have hired somebody I don't know, a public defender, somebody.
They name Higgins, Albert. They invoke those names. They characterize third-party culprit. And they suggest that some anonymous person was uncomfortable.
I believe it's Lori Vallow. Let me look her up. My phone's charging. I believe that's her last name. But she's already serving she's serving life sentences. Let's see, Lori. Yeah, it is Vallow. She's serving life sentences. I did not really watch the first trial because kids, like minors, were victims. I stay away from stuff like that or cases like that. But now she's on trial for, offing her husband. She's serving a life sentence though. But actually, she made not a weird request, but she made a questionable request in court today. She asked for a joinder of two different trials. One, she's accused of offing the husband. The other, she's accused of offing her nieces, or attempted murder of her niece's husband, and she apparently wants them joined. There's a reason why defense attorneys actually do not want cases of that nature joined. But yeah, I have to figure out how I'm going to deviate my time. And again, Lori's trial I expect it to be very interesting. But I'm kind of already invested in Karen Reed, so I suppose that's actually where where my focus should lie.
It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever.
There you go.
All witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered.
Okay.
But I've specifically asked that they not be sequestered. I think that an accused has a strong need.
Brennan probably.
Good morning, everyone. Fox 10.
No.
Justin.
No, we don't want to listen to Phoenix News right now. Brennan is actually, so far, he appears to be fair because, again, hardline prosecutors would have Karen Reed's folks, excluded from the courtroom unless and until, they get to the stand.
Need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. the idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may, or even if they do become witnesses.
Okay,
Okay.
Your Honor, if I could address one issue.
sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
Okay, I guess the rest of this I did not watch because I was working. So let me, not that I wasn't working the past hour.
One might have been
Right.
yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
Okay, so let's go. Let me think about this. Okay, let's flip and talk.
That's also mine, Your Honor.
Okay,
I believe the Commonwealth has indicated that they will agree to that.
okay.
Yeah, that's what I was about. Hold on. What was the motion?
All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Let me think. I'm going to have to take time to think about that one because what would be the prosecution or, the defense? The defense, it's obvious. Their interest, it's obvious because they don't want it to come to light that, or at least they don't want the jurors to be made aware that they, paid these Ackard witnesses. But what are the prosecution's interests in potential jurors not knowing that the witnesses were paid? I don't know. That one stumped me a little bit.
Okay,
I believe the Commonwealth has indicated that they will agree to that.
Okay, panel voir dire.
defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once
I
they've
think that made sense.
taken the stand. So is there an objection to that, Mr. Brennan?
There's not, I believe that rule should apply to both sides. I have no objection.
Okay.
Okay.
Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay.
All right. I'm going to fast
All right, the
forward a
next
little bit because I don't have that much time. Dang. Is she still in the office? Anyways, I don't know. Okay, let's fast forward because this
One is paper 571 and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense.
Hold
Who's
on.
for it or have the Commonwealth argue
I'm sorry,
their,
guys. I love listening to Alessi talk.
make their argument for admission of it? Who's arguing it for the defense?
Your Honor, I am. And to
Okay.
answer your question, the defense preference would be for the Commonwealth to go first. And
All
we
right.
would respond, including with regard to my motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a,
Brooklyn. So Brooklyn wants to know if I think that the witnesses were paid for bias or paid for expenses. Again, it really doesn't matter, because if we go back to when I say that it doesn't matter, the fact that they were paid does not matter. Again, um, expert witnesses are said to be impartial, but in actuality, that is not the case. They're called for a specific side for a specific reason. Regardless of why they were paid, it was stupid of the defense to try and hide that. It made no sense, because, again, witnesses get not all witnesses. Expert witnesses get retained all the time. They're professional witnesses. There's an expectation that they get paid, right, for their services. It's just, I don't know. And then, as far as bias, if we do go back to the actual hearing itself, I believe, I think it was Brennan. When Brennan was reading out the communications or the correspondence between Jackson and one of the expert witnesses, okay? I believe, and I'm going to paraphrase because I don't actually remember the exact words that were used, but it was something to the effect of the witness was prepared to testify in line with Jackson's position or suggestion. So to me, that does signal some bias, but I've said it before. Listen, in my job as a prosecutor, not so much. Most of my witnesses were, law enforcement, medical doctors. And again, medical doctors, they're just testifying to their treatment or, an autopsy, things along those lines. A cause of death, things along those lines, a coroner. As a public defender, I'm trying to think. Public defender, I've actually never used an expert witness as a public defender. I usually used family members and loved ones. But currently, with what I do in civil practice, we hire experts all the time. Today, we spend time, editing an expert like an actual doctor, okay, an orthopedic surgeon's report, okay, editing the report. And again, the expert can decide whether they're going to take our edits or they're going to disregard them. Some experts don't allow you to edit their reports at all. That said, though, I still do not understand why Jackson took the route that he did. Again, maybe from a defense perspective, maybe he did not retain as many experts, but just from a civil perspective, folks are not really, they're not really neutral. That's just, that's the fact of it. And then let's see, Brooklyn saying, what's going on? What do you mean I like nerds? I just think I like the way he argues. He's a little argumentative, but I like it when him and Brennan go at it because they're just arguing about the law. They're taking the same facts, focusing on specific aspects of the same facts, and it's a show. That's what I like. I like that. But I really do like Alessi. Let's see. I think you said something.
OUI manslaughter and murder
Wait.
case. The statutes that the defense cites
Okay, this I-
don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol.
Okay.
We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible, Commonwealth versus Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are
I'm sorry, I received the
agencies,
message.
hospitals are facilities that have standards that comply.
I know, Brooklyn, do you not like Alessi? Because I think by far, as far as what is this? As far as skills, again, real skills, we're going to assess that during cross, because that's where you tell if an attorney actually knows what they're doing. So far, Jackson, it's established he knows how to cross-examine. I'd like to see how Alessi actually fares during the trial. That said, though, I really like Alessi. Jackson has left a bad taste in my mouth just because I do not condone improper conduct from either side. And in this case, it was very stupid. Like, I wanted to say it's one thing, like hiding evidence. You cannot even do that. Hiding evidence for a criminal defendant, you definitely cannot do that. But I'm really stumped. I'm stumped by his decision. I've never been a winning at all costs type of attorney, be it prosecution or defense. That's just not my style. I don't know. It makes me question. It makes me question his integrity. But so far, Alessi's fine by me. I mean, he may have been one of the attorneys that actually signed off on the BS, but I still like him.
That are trustworthy, and this evidence should come in pursuant to
I
those
agree.
cases in that statute.
Yep.
All right. Now I'll hear
Yeah,
you.
Alessi's definitely a breath of fresh air. But to me, I think he makes cogent arguments. He makes arguments that make me want to listen to him. I don't have to agree with the argument, but I'm like, oh, I didn't think about it from that perspective. Whereas, again, I'm probably being too harsh against, I forgot her name already. I actually forgot her name. The female attorney, Little, I believe that's her name. Again, to me, she appears to be a baby defense attorney. If she's not a baby defense attorney, then I don't know, it must be nerves or something. But with Alessi, I can still follow what he's saying. I can understand what he's saying. I can see where he's going. And I like the fact that he actually argues. He has a response. Yeah, so I like that about him.
Mr. Alessi?
All right,
Thank
come
you,
on.
Your Honor.
Yeah, he tried to knock out Brandon. He tried to knock that man
Now I'll
out.
hear you, Mr. Alessi.
Thank you, Your Honor.
No excuse me, nothing. All right, come on.
Attorney Brennan misstates our position.
I like the way, I absolutely love listening to Brandon and Alessi go at it. They always sound like they're reciting, I don't know, they're reciting something, a poem, literature, something. But I just need to go back to that because I like the way he starts off.
Attorney Brennan misstates our position that
Okay.
is clearly set forth in our papers.
All right.
We are not citing to statutes.
Yeah, Jackson has lost credibility. I just hope that this is not something that goes on to bite him in his behind down the line. Okay. What I mean by that is, the board of ethics. I don't know why he did that. Because this is it's one of those instances where you just never know. You never know. He might be opening himself up to being investigated. It makes no sense. Anyways, enough ranting. Let's move on.
That discuss consent of Miss Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable. And here's why.
Okay.
There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up in ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states to.
All right, I'm gonna have to re-listen to this part at the office tomorrow. I was parenting you guys, but I'm not gonna go back. I'll just let it play out.
Paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion and that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors. And it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
Okay.
All
It
right.
should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay,
Can I just respond briefly?
sure.
Thank you.
Yes, we have the last word.
Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial
I like Alessi. He's fine by me.
to establish it. That should have been in their motion in opposition, that they should have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to
Okay.
defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced
Yeah,
that
and
as
we did not. I believe it's. I skipped over that part, but the episode, I forgot, the Karen Reed documentary that aired last night, that was brought up in today's hearings. Again, it just puzzled me. I really do not understand why. I don't understand why the defense have Karen Reed parading around. I mean, I understand why. There's a specific reason why they're doing it, but it's still puzzling to me. I don't know that it's a sound decision, but you know.
Directive of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history.
Okay.
Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion
That's
is
funny.
allowed. That's 574 is allowed, Mr. Clerk.
All right. What's next?
All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Take way too many sidebars. Too many sidebars. Dang, so I mostly just missed the fan. That's what I mostly missed.
So, Mr. Jackson, I'll hear you.
Okay.
Court's back in session, you may be seated.
All right.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action.
Okay.
That would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be 2 days hence. So
Okay.
the briefing is going to be done in relatively
What's
short
going
order.
on?
The decision, that's another question.
All right, thank you very much.
Of course.
Does it make sense for me to hear from Mr. Spillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Okay.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right,
really
Mr.
young.
Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The
Okay.
defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that.
What's
I
up,
think more broadly,
Angie?
Your Honor, in terms of the arguments here.
Yeah, you did not miss much. Most of this was like a fan flying around. So we had to skip that.
Certainly, if it were possible to
Are you working today?
have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which. At the same time, Commonwealth is obviously strongly opposed to moving the trial.
Okay.
And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members. And to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule, that would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
Okay.
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay.
Okay.
That's fast.
Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury.
Okay.
So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
Yeah.
May we address the court at sidebar on one issue
Tomorrow.
before you leave the bench?
Sure.
So I guess they'll be in court on Wednesday, not Thursday. That's what it sounds like. I guess they don't come back.
Time, Mr. Schilling. All right, tomorrow, but Thursday morning at 9 o'clock.
Oh, so I
That'll-
guess she was missed.
All right, tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay.
All right, so we'll end right there. I was actually up here much longer than I'd planned. So tomorrow we will get into what we were supposed to discuss tonight. We might actually just get into Valerie. I don't know, Brooklyn, you said you don't know who Lori, I called her Valerie. Lori Vallow is? I think it's also Lori Daybell, if I'm not mistaken. Yeah, we might get into her because she is something else. This might be our only chance. But I still wanted to take a look at Karen Reed. I wanted to go back to actually when the court declared that the jury was hung, because that's what we were supposed to discuss today. But I mean, we might actually get into Lori because she was something else in court today. All right, folks, I'll be back tomorrow. Tomorrow's what, Wednesday? I'll be back tomorrow, 8:30 p.m. Eastern time, okay? Big shout out to Brooklyn and Benji. See you guys tomorrow. If not tomorrow, then the day after. All right? Okay, I'm gonna shout out to the replay crew.